One case you have, and this is an actual case, it was an orange juice dispensing machine in the store. It had a kind of a fluid that was slowly dripping out, one drop at a time, that you could show took a long time to puddle up on the floor. And our client walks along, he's looking up at the shelves, you know, deciding what they want to buy. Slips, falls, and hurts themselves. Okay. Now, the store usually has a log they fill in, so they walk the aisles every hour, and that's considered reasonable. But in this case, we were able to show that it took more than an hour for that to accumulate, and therefore the store knew, it's a new or should have known standard, that they should have known that it was there and cleaned it up. And therefore they were liable for that person's injury. Now, let's go to case number 2. You have a clear cellophane package of dried black-eyed peas.
Oh boy.
And somebody just ahead of you has a child who goes through there and with something punches a hole in the black-eyed peas, and they spill out on the floor, and you come along a few minutes later and you fall and hurt yourself. Now, the store had no way of knowing that, and you can't prove that it took a long time for that to be on the floor. So you may or may not have a case, but probably not.
Probably not?
Yeah, you're talking about constructive knowledge. There's 2 types of knowledge in the premises case. You have actual knowledge, that is they actually knew about the hazard. They'll never admit to that unless they created it. And then constructive knowledge, and the way you prove that is either by they have an employee in the area of the hazard and an opportunity. That employee can't just be there, they have to have enough time to see it, appreciate it, and remove it. Or you can prove that they didn't have a reasonable inspection protocol. Either one of those will help you get to constructive knowledge.